But to that point, what do you think of judges? Are you comfortable that the pro-gun majority that exists on the court now would survive a Harris administration?
I don't know which Republican would retire in a Harris administration. Like that, that's, as of right now, both Samuel Alito and Clarence Thomas, the two oldest justices, show no sign that they want to step down, certainly not under a Democratic administration. And then the other thing to realize, Stephen, and I'm glad we're getting into this, the pro-gun majority on the Supreme Court is not as pro-gun as people think. And we learned that very clearly in the Rahimi case, very clearly. And I have not seen enough conversation about this in the larger gun rights community, because I think one of the issues is this new legal test, text, history, and tradition. It's so new to people, they don't really know how to interpret it. But let me put it this way. The way the Supreme Court articulated the text, history, and tradition test in the Rahimi case, this was the case that said that yes, the federal government can in fact prohibit people subject to a domestic violence restraining order, can prohibit them from having a weapon. So that was the holding of Rahimi. It was 8-1. The only holdout here was Clarence Thomas. Right. But what's even more interesting than 8-1 was what the conservative members of the 8 justice majority, the 5 conservative members, how they explain their position. And if you look at it and you read it carefully, what they're saying is that their understanding of text, history, and tradition gives the state legislatures a pretty wide berth to regulate weapons and individuals that they believe to be extraordinarily dangerous. And so the practical result of Rahimi is literally, Stephen, I don't even know if an assault weapons ban would be struck down by this court after Rahimi. I really don't.
That's interesting.
Because if you look at the way they talked about history, they did not talk about history in the sense that Clarence Thomas wanted them, which was for a gun control restriction to be upheld, you need to find a historical analogy that's very, very, very close. So, for example, he was saying you can't do a domestic violence restraining order restriction on gun ownership because history shows there's another way of doing of limiting access to weapons by dangerous people, and those are called surety laws, where somebody puts up a bond that they forfeit if they misuse the weapon. And so he was saying because there's that historical model, that's what you have to go with. Whereas the majority, the 5 justices, the 5 conservative justices plus the 3 more liberal, said something very different. They used it much more like, okay, I'm going to look at the historical record and see if colonial era or immediate post-ratification legislatures were concerned with dangerous people and things, and did they regulate dangerous people and things? And if the answer is yes, then that's creating a permission structure for us in the current moment to regulate dangerous people and dangerous things. And then there's this interesting part of the Heller decision that a lot of people haven't focused on. Mm-hmm. And this interesting part of the Heller decision explicitly says that, and this came up in the Fourth Circuit en banc ruling upholding Maryland's assault weapons ban, that the Heller decision explicitly distinguishes weapons that it calls M16s and the like. Yes. M16s and the like is the actual phrase that can be regulated, right? Well, what does and the like mean? Does it mean identical, just like M16? So an M4 with a 3-round burst and an M16 with a 3-round burst or a fully auto mode? Or does it mean substantially similar to? In which case, an AR-15 semi-automatic that is used exactly the way M16s and M4s are used downrange, does that mean substantially similar to? Nobody really knows. And so it's very up in the air, even looking at Scalia's precedent in Heller. So it is not the case that right now the federal judiciary is solidly and strictly opposed to gun control regulation. It is the case that they protect a right to have a weapon in the home for self-defense. They protect a right to bear a weapon outside the home from self-defense, subject to reasonable regulation. And then we don't know where they stand on assault weapons or large capacity magazines.